Welcome to Constitutional Chisme.
A law baddie's guide to the legal basics. I'm your host, Stephanie.
And I'm your co-host, Harleigh.
Every week, we will drop an episode that you'll likely cover your first year in law school or some other bar course in your law school journey. Make sure you pay close attention to our podcast because we will drop Easter eggs of what case we plan to drop next week. See if you can guess which one.
This episode is sponsored by Belmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. We also want to thank Kaplan Bar Prep for partnering with us. If you or someone you know is planning to use Kaplan for bar prep, be sure to use our code PASSWITHPONZ to save an additional $100 off your course. This same code will also get you 20% off any of the Kaplan Bar Prep supplements. Using this code not only helps you save money, but it also helps support the show and make sure that we can keep giving away bar prep for each testing site. Be sure to check out our link tree in the show notes, where you can find links to follow us on TikTok and Instagram, access our Amazon storefront featuring our favorite law school and bar prep essentials, and you can also join our Patreon community for even more content and to help support the show. You guys should send Stephanie a present from Amazon. She's really going through it right now. We're like at T-minus 3 weeks until she takes the bar, and she could really use a pick-me-up.
No, I really could. I'm dying. If I keep getting more MBE questions wrong, I'm going to crash out.
So send her something so she doesn't do that. And welcome to everybody who's like new. If this is your first time listening, if you just recently started listening, or if you've been listening since episode 1. Hi, we love you. Thanks. Yeah. Anyway, so I'm going to go ahead and back you all the way up to 1963. So
oh, wow.
We just did the 80s, back it up 21 years to Halloween. Halloween, October 31st, 1963. It's spooky season.
Gosh.
And something spooky happens. The police.
That's scary. Jump scare. Wait, what is the funniest costume you've ever had for Halloween?
Me personally?
Yeah.
Ooh. I don't know. I don't know that I've ever done like a funny costume.
Really?
Yeah.
I only do trolling costumes because I think they're hilarious.
I'm trying to think. I haven't really gotten to dress up for Halloween in a long time.
Did you not dress up in law school?
I never went to ex parte.
Didn't you go to the parties beforehand, though?
Mm-mm.
Are you serious?
Yeah.
Why did I think you were there?
I don't know. But every year I had something come up and I didn't get to go. And I was really sad about it.
That's so crazy.
Anyway. So it's spooky season. Right?
Wait, you're not going to ask me my costume?
Okay. I don't know. I don't think I ever did anything funny particularly. Do you have one? Have you done a funny costume?
Yes. I actually won 2 awards for this costume.
Oh my God. Wait, is this the croc?
Yeah.
I forgot about the croc.
I want you to know that I spent a ridiculous amount of time to create a croc costume. And I believe I was a left croc, I believe.
That's crazy. I totally forgot about the croc. I totally forgot about the croc costume.
And I bought pink glittery crocs. So if anyone had no idea what my costume was, I could point at my shoes and be like, I'm a croc. And so I will say I committed to the bit because it was heavy. It was all made out of cardboard, handmade, and I won tackiest costume and most creative. So I got like $50.
Oh my God.
Yeah, it was so cool.
I completely forgot about the croc costume. That was such a good. I remember when you posted that. Because like I didn't get to go, but yeah. I remember all the pictures and I was like, that's simply genius. You have to repost that now so everybody can see.
Yes, I love it so much. I think it was the coolest costume. I don't know how I came up with it or when or anything, but I just knew that that's what I needed to be. And yeah, I had the handle and everything. I couldn't fit anywhere. I had to turn sideways. Like it was.
But you know what? The commitment to the bit.
Yes. And guess who won a gift card? Not one, but two. This girl.
The croc.
The croc. No, that's when they announced, because like we were 1Ls, and so no one really knew each other's names. It was our first year of law school, and at least I'm horrible with names. And so whenever people entered in who they thought should win, people put in the croc. So when they announced me as when they announced me as the winner, they go, the tackiest costume goes to the croc. And I screamed. I was so happy.
Oh my God. Okay, so now now for the rest of this case, I want you to make sure that everybody's dressed as a giant croc. Okay, keep that.
Yeah.
So it's 1963. I don't even know that crocs had been invented yet. Whatever.
When were they invented?
That's an excellent question. We're never going to get through this case because I'm going to keep.
I'm sorry.
No, I'm obsessed because I need to know now.
2002.
Okay,
no,
so
you're
crocs
right.
didn't exist yet.
I'm going to put a croc in the photo for this promo.
Perfect. So, okay, so police officer Martin McFadden was on duty in Cleveland, Ohio. This is the most serious case we have to lock in.
Wait, was it McFaddy, yes or no?
No, McFadden.
Okay. All right, go ahead.
I don't know what this man looked like, but nobody was fat in the 60s. Those were the rules.
That's why I wasn't born in the 60s.
Me either, queen. I was born in the 90s and lived through the 2000s. It's a rough life out here.
Okay, sorry, I'm locked in.
Lock in. Okay, so Officer McFadden was on duty in Cleveland, Ohio, when he noticed two men just standing on a street corner. Okay. That's it. That's all they were doing.
Mm-hmm.
And of course, that meant that he had to intervene because you know what a police officer's not going to do? Mind his business. So,
wait, that reminds me of that ad where it's like, oh, you hate police? Well, next time you're hurt, call a crackhead.
That's Senator Kennedy. Senator Kennedy from Louisiana.
Oh, God, you know him?
One of my co-clerks worked for him on Capitol Hill.
What was that?
And she said just as funny in real life. Like, he's always like that. Unfortunately, he is super funny, even if I don't agree with his politics at all. He is really funny. Another personal favorite quote of his is, I don't understand why we keep giving money to countries that hate us. I think they should be able to hate us for free.
Okay, I'm sorry. I'm locking in. That was just so funny.
One of these men was John W. Terry. So Terry is walking down the street. He stops. He looks in the store window and then walks a little bit further, turns around and goes back to where he started. And then the other guy who was with him, Richard Chilton, did the exact same thing. So he walked, he looked in the window, walked a little bit further, turned around and came back. So McFadden's watching them and he goes, I think they're casing the store. I think that they're planning on robbing that place.
Because he looked in the store?
Because he looked in the window, which is obviously...
Like window shopping?
Well, it is nighttime.
Oh, okay. Okay, you can window shop at night.
You can window shop at night.
Okay.
Also, God forbid a guy check his reflection in the window.
Yeah.
You know what I mean? You've never done that? It's Halloween.
I do it all the time. I was a croc. Of course I looked at myself.
He was a croc. He's looking. It hadn't even been invented yet. This is groundbreaking. Okay, so McFadden's watching them. He's like, oh my God, they're definitely planning on robbing the place. So he confronts them. And he's like, what are you guys doing? What are your names? And they don't really answer him. They kind of like mumble. They're like, no, I'm not telling you that. So McFadden then grabs both of the men and frisks them.
What does that mean?
So he basically does like a quick little pat down of both of the men and discovered that they both had pistols in their jacket pocket. So Officer McFadden arrests both Terry and Chilton for suspicion of carrying illegally concealed weapons.
Mm-hmm.
Both men were charged and tried in the Ohio Court of Common Pleas for Cuyahoga County. Terry's lawyer filed a motion to suppress, which we talked about last episode. It's a motion that basically says this particular piece of evidence, whatever it may be, violates my constitutional rights. So it shouldn't be admitted during my trial. So his lawyer files a motion to suppress, seeking to suppress the evidence of the discovered pistol. And specifically, Terry's lawyer argues that when McFadden frisked Terry, that was a violation of the Fourth Amendment. And so therefore the pistol should be excluded from evidence. The trial judge said nope and said stop and frisk is perfectly legal. So that's going to come in, and Terry was ultimately convicted. So Terry does what every reasonable person does, and he appealed.
Mm-hmm.
Not every reasonable person. Let me be clear. The Venn diagram of who appeals cases is not the Venn diagram. It's a rectangle square situation. Okay, everyone who appeals is not reasonable, but every reasonable person appeals. Okay. All right. So he appeals to the Ohio District Court of Appeals, which said, no, the trial court got it right. They said what they said. So he took it to the Supreme Court of Ohio. And they said, we're not listening to that, actually. So he said, actually, screw all of y'all. And he went straight to the U.S. Supreme Court. And they said, you know what? Hell yeah, brother. Get in here. And they granted certiorari.
Wait, what is that again?
So again, that's when if the Supreme Court grants certiorari, it means that they are going to hear the case.
Okay.
So they grant certiorari. And then on June 10th, 1968, the Supreme Court issued an 8-1 decision against Terry. And they said that stop and frisk was indeed constitutional as long as the police officer has a reasonable suspicion that the person is about to commit a crime, has committed a crime, or is in the process of committing a crime and may be armed and presently dangerous.
Okay.
So, looking specifically at the court's opinion in this case, the opinion was written by then Chief Justice Earl Warren. And the court accepted some of Terry's argument that the Ohio courts had not. And that was basically that McFadden's stopping, questioning, and frisking of Terry and Chilton had been actual searches and seizures under the Fourth Amendment. So the Ohio court just straight up said the Fourth Amendment was not implicated in this case. The Supreme Court says, no, it's implicated, but the searches and seizures that occurred during the stop and frisk were not unreasonable under the amendment's first clause. So remember, the Fourth Amendment protects you against unreasonable searches and seizures.
Yeah.
So not just being searched or being seized. So because it wasn't inherently unreasonable, it's not in violation of the Fourth Amendment. So the court said both the initial stop and the subsequent frisk were so, quote, limited and brief that a lower level of justification was enough. So both that initial stop and the subsequent frisk were so, quote, limited and brief that a lesser justification was enough, rather than the police having to come up with probable cause beforehand. So all they need is reasonable suspicion, not probable cause, which is a lower standard.
So it's actually easier to frisk someone then?
Yes, because all you need is reasonable suspicion that they are about to commit a crime or that they have committed a crime. They don't need full probable cause.
And so at this point, you can frisk someone, and that doesn't mean that they will go to jail, so you don't have to give them a Miranda warning for the frisk, right? Like, that doesn't automatically mean that the officer has to give a Miranda warning, or do they?
No, they do not have to give a Miranda warning for a Terry stop. So very similarly to what we see later on in Berkmer, and specifically the holding in Berkmer kind of harkens back to the idea of what is now colloquially known as a Terry stop.
Mhm,
So Berkmer basically adds on to this idea of this is such a brief amount of time
mhm,
that your constitutional rights are not implicated to such degree that the higher standard needs to apply. So in Berkmer, when you have just a traffic stop, yes, you're technically detained. You can't leave,
mhm.
but you're not so detained that you have to be told what your constitutional rights are to avoid being pressured into giving a confession to a crime. Same thing with a Terry stop. You are technically being searched, but you're not being searched to such a degree that the police need to have probable cause.
Okay.
So, specifically, the Supreme Court pointed back to the fact that police officers need to protect themselves. And the court basically reasoned that the need for officers to protect themselves outweighed that very minimal intrusion that's happening for a frisk. So the court says an officer can stop a person if they have reasonable suspicion that criminal activity was afoot, and then frisk the person that was stopped if they had reasonable suspicion that the person was armed and presently dangerous.
Okay.
And neither of these things require that the police have that higher level of probable cause that would be needed to arrest someone or conduct a full search. So again, there's cases later on that kind of add to this, but this has to be a very preliminary search
Mhm.
to determine whether or not somebody has a weapon on them.
So you can't just, like, let's say they have a super flat wallet. You can't just search their wallet because it wouldn't be reasonable to think they have a gun in there, right?
Exactly. So it's this very particular, like, pat, 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 pat to make sure that they're not actively carrying a weapon that they
Mhm.
could then pull and use on an officer.
Okay.
That's the very narrow exception here. And again, the Supreme Court will later on kind of clarify that a little bit more, but this is kind of the first time they touch on when you get so far into the Fourth Amendment that probable cause actually attaches. Now, the thing about Terry versus Ohio is
Mhm.
that it's also a very controversial opinion.
Mhm.
Now, again, this is coming out of the 1960s. So this is obviously a time when, the civil rights movement was kind of picking up steam.
Mhm.
There were a lot of racial tensions in the United States. And
Mhm.
so a lot of then critics and modern critics of Terry have said this is basically a green light for officers to essentially profile people
Mhm.
and say, you look like you're committing a crime. And I've decided that because you are Black, you look like you are committing a crime. Which is what a
Mhm.
lot of people say Terry kind of gave credence to, kind of gave officers the green light to let their own internal biases run rampant. And then they
Mhm.
could just stop and frisk and detain whoever they wanted to for however much time. Because again, at this point, when something goes past a Terry stop
Mhm.
into an actual detention has not been made perfectly clear. So, at what point does an officer go beyond just simply stopping and frisking and is kind of trampling all over somebody's Fourth Amendment rights for the crime of walking while Black, essentially?
Mhm.
When you sort of present this all-encompassing power of saying, I think that person is committing a crime, and you really don't have to articulate anything beyond kind of a gut feeling.
Mm-hmm.
You are condoning
Racism, people being
Yeah, you are
biased.
condoning people using their own inherent biases to make on-the-ground decisions that could lead to people losing their lives.
Yeah.
So, once the court had kinda set this precedent of the fact that, like, you just have to have reasonable suspicion, like, that's the standard, you don't have to go to the level of probable cause, they then applied that concept back to the interaction between Officer McFadden and Terry. And they were like, "Yep, that perfectly comports with reasonable suspicion." Officer McFadden had all these years of experience as a policeman and was able to articulate what he had seen and why that made him suspicious of the fact that Terry and, the men who were with him were preparing to rob the store. So,
Mm-hmm.
based on that experience, he reasonably suspected that the men were preparing for robbery. They were preparing to commit a crime,
Mm-hmm.
and therefore he reasonably suspected that Terry was armed. So his
Mm-hmm.
frisk of Terry's clothing was perfectly acceptable and did not ultimately violate Terry's Fourth Amendment rights. Now, towards the end of the opinion, the court did say this is meant to be held very narrowly.
Mm-hmm.
So
Has
specifically,
it
it said
been?
it has kind of ebbed and flowed. So I know that we've talked before about like how the Supreme Court handles precedent can change depending on who is on the court, unfortunately, and like the way that they interpret the law with their own personal understandings
Mm-hmm.
and personal beliefs, whether they intend to or not. So, how far Terry reaches and how narrow the holding really was in Terry has kind of waxed and waned in the, 70 years since it came down?
Mm-hmm.
60 years since it came down. But it has typically been a rather narrow holding. And
Mm-hmm.
specifically, the question that it was meant to address was whether it's always unreasonable for a policeman to seize a person and subject him to a limited search for weapons unless there's probable cause. And in that very limited question, the court said no. And that has typically been the spirit of Terry, and it has typically been held to that particular standard. But
Mm-hmm.
how far an officer can go in a frisk has been a little different over the years.
Mm-hmm.
Now, typically, the standard is, and at least this is how we were taught it in criminal procedure,
Mm-hmm.
the typical tipping point is just patting a person down. And if there's what an officer can reasonably ascertain to be a weapon, they can
Mm-hmm.
search in order to retrieve that weapon.
Mm-hmm.
But if they're like patting somebody down and like you said, they just feel their wallet, they can't then reach in and pull out their wallet
Yeah.
and start going through it.
They're gonna look at this as a whole and like the situation, and if they see something like that, they'll be like, "Hey, no, that one's too far." Right.
Yes. Yes. It's a very fact by fact analysis, case by case analysis. And that's
Mm-hmm.
why I say it can kind of sometimes feel sticky if
Uh-huh.
you are a law student who's like going through it. Right now, I can tell you that the precedent is a little bit more narrow because this issue hasn't gone back up to the Supreme Court in a while. But as you go through and you're learning some of these cases in criminal procedure, it's going to feel a little bit roller coastery
Yeah.
as you determine, is that okay? Are they allowed to do that? Is that allowed? Wait a minute, is that allowed? But I think one of my favorite hypos that our professor gave us was if someone has a packet of drugs that happens to be shaped like a gun, like they decided to shape their
yeah.
their drugs into a gun,
Then
that
that's reasonable.
if an officer then pulled that out thinking it was a gun and goes, "Oh, this isn't a gun, this is cocaine," the officer is not like that evidence is now not going to get thrown out
Mhm.
because the officer reasonably believed it was a weapon when he took it out, and it just so happened to be evidence of a different offense.
Yeah.
So that's a little crazy. No one is shaping their cocaine into gun shaped. There's no gun shaped cocaine. Okay. But I don't know why that's the hypo that always stuck with me.
It's going to be the next crime we see on TV.
And now watch tomorrow. There's going to be a guy arrested because he got Terry stop and frisked, and they found a gun shaped hunk of cocaine in his pocket.
That's hilarious.
But the ultimate rule is that when a policeman observes unusual conduct which leads him to reasonably conclude, in light of his experience, that criminal activity may be afoot, and that persons with whom he is dealing may be armed and presently dangerous, it is not a violation of the Fourth Amendment for that policeman to then conduct a stop and frisk of the people of whom he suspects. And for better or worse, that is the case of Terry versus O.
Awesome. Well, I think that was very well done. All right, guys. Thank you so much for listening. Excited for all the new listeners, all the returning listeners. Again, if you want to follow us on any of our social media platforms, it's located in the show notes. You'll find our link tree. Click that. You can find all of our discount codes. You can find where to follow us on social media. You can also find our Patreon, where we are still waiting for you guys to join.
And if you want to hear more about these particular cases, the Patreon is where we will put dissents for each of the cases, a discussion of the dissents of each of the cases, and where there will just be lots of cool bonus content that, only our Patreons get access to. So I don't know. Go check it out. Sign up. Support the show.
Well, if anyone is sad that I have to sit for the bar exam again, feel free to Venmo me coffee money.
It's bad for me, just generally. Venmo me.
Stop. You have a job. Get out of here.
Okay, I can't beg on the internet too. I work for the government. They pay me peanuts.
Do you get coffee twice in the same day? Yes or no?
No,
You're a liar.
I'm not.
Okay, well, Maggie needs to do that video where it's like my Netflix documentary. It's like my Netflix documentary about Harleigh buying 2 coffees.
I stop at 7 Brew. I'm not going to keep explaining this. I stop at 7 Brew on Tuesdays.
Okay, guys. Well, thank you for listening. We'll see you next week. Bye.
Bye.